Welcome everybody. Hello, my name is Barry Taylor. This is the Disability Rights Consortium. I want to welcome all of those of you who are in the room. We're also have people participating by phone, and we also have folks via webcast. So we're sort of on all cylinders of technology today.
Do remember, though, as you make comments and questions, that this is something that's going out to the world, so keep that in mind as you say whatever you want to say. Today we're really fortunate to have sort of the premier scholar, I think, in special education law, Mark Webster, who's a professor at DePaul. I always say he literally wrote the book on special education, and I actually have a visual aid this year. Hot off the presses is Mark's Special Education Law and Litigation Treatise. He's given us to Equip for Equality to use as these issues come up. Thank you very much, Mark. And I'm not going to take any more of his time. I'm going to let him take it from here. And thanks very much for being here today. Thanks very much, Barry. I'm glad to have all of folks here. It's an honor to be here. The plan is to go through recent developments in special ed law, mostly cases with a few other things like Department of Ed interpretations and a couple of Office for Civil Rights letters. I should mention I will be pausing every now and again if folks have questions or concerns. Must be frankly, if you're in the room and you just want to raise your hand or something, that's fine. It's not that big a group or that formal a presentation that really would create problems for folks to just jump in when it's appropriate. That would be just fine. Should probably also say a little bit about what I'm going to cover in terms of the various new developments. So what I tried to do is take things back through calendar year 2016 and 2017. And then cover pretty much all of the cases that are local. So Northern District, Southern District of Illinois, 7th Circuit, U.S. Supreme Court, of course, anything out of the Illinois courts. There really wasn't much of interest in special ed law out of the Illinois courts. I'm actually throwing in a couple of hearing officer decisions, which I think are of real significance from the course of the last year. And I try to be really comprehensive about that local stuff, but when I'm throwing in a fair number of out-of-state or out-of-jurisdiction type developments, and for that I've been really highly selective. Probably with a bit of bias in favor of looking towards cases where the parents or the kid prevailed in a claim. So don't take the success or failure ratio as being indicative of what really happens in the real world. Parents and kids probably don't win a majority of cases. Although it's really hard to tell because you never know what gets reported, what doesn't, what happens with settlement, what else. But it's true that a lot of the cases where the parents lose tend to look a lot alike. And the more newsworthy cases tend to be the ones where the parents prevail. So I tend to emphasize those rather than anything else. I think probably just to jump into it, what we should talk about are the elephants in the room, the two big cases out of the Supreme Court this term. The first one is the Fry case, which came down in February. This is the big case about administrative exhaustion. Justice Kagan with a nearly unanimous court. There's a separate opinion by Alito and Thomas. The case involved a kid with cerebral palsy, had a service dog named Wonder, who assists considerably on everyday sort of tasks, like picking things up, calming the kid down, any number of things that would be of assistance to a kid with fairly severe cerebral palsy condition. The school was highly resistant to having the kid bring the dog to school and allow the dog at one point for a trial period, but most objected to having the dog said, no, we'll give you a human aid instead, so you won't need the dog for that. Kid and parents, on the other hand, were saying no. For one thing, the kid uses this dog all the time elsewhere, and it certainly wouldn't reinforce the use of the dog to have the dog available at school. But also, we don't really want reliance on other humans. What we want is self-direction wind up filing an Office for Civil Rights complaint, which decides in favor of the parents, but after that begins to be implemented, the parents are so concerned that there will be resistance on the part of the school that they enroll the kid in another district, which turns out actually welcomes the kid and the dog, and doesn't create any problems thereon. But they ultimately then sue for damages under Title II of the ADA and Section 504 for the travails that they went through for this period of time. Sixth Circuit says no, you can't do that. If you want to bring a claim like this, you have to exhaust administrative remedies. The parents push back and say, no, we don't. And so it goes up to the U.S. Supreme Court. Supreme Court vacates and remands. And it's a fairly major kind of thing in that regard because it really is the first case that the U.S. Supreme Court has had on the exhaustion requirement in special ed cases for ADA Section 504 claims. Key provision here is what's now known as 1415L of Title 20, overruled in an early case from the 80s called Smith v. Robinson. And said it's okay to bring claims under Section 504, the ADA, the Constitution, whatever it is, but if you're seeking relief that's available under IDEA, you have to exhaust the same extent that you would an IDE claim. And of course, that's the provision for which all sides are arguing, or over whose interpretation all sides are arguing. Justice Kagan for the court said, well, the key thing about IDEA is what it gives a right to a free, appropriate public education. And we think that the remedies to provide are for denial of a free, appropriate public education. So therefore, if what you're seeking is a remedy for denial of a free, appropriate public education, you've got to exhaust. On the other hand, if what you're seeking is something else, a remedy for something else, then you don't have to exhaust. Some ways that might just make the question more difficult rather than easier because you don't know for sure what's claimed for denial of free, appropriate public education. But the court does give what they describe as clues to try to handle that. And the couple of them that they seem to say would be indicators of the case not being one for free, appropriate public education would be if the same kind of claim could be brought in a non-educational setting. So for example, if you've got a public library that doesn't have ramps, or if you've got, say, some other building or public service that doesn't have communications availability, that would be an indication that the case is one that doesn't need to be exhausted if you're making the same claim with respect to the public school. Similarly, an adult could make the same claim, so again, ramps could be an example, then that's yet another clue. On the other hand, if the parents have begun the administrative process through IDEA, the court says, well, that's kind of a negative indicator. Court does say that what you should look at is the gravamen of the complaint. The parents will end up being the master of the complaint in civil procedure parlance. And so they're able to frame the case in a way they wish, but the court should look through whatever the pleadings are to see what really is going on and what is really a case over denial of FAPE, free appropriate public education. Interestingly, the concurrence that Aleo comes up with along with Thomas is, if anything, somewhat more pro-parent or anti-exhaustion, if you will. What they say is that the indicators may not really be all that helpful, that there's a lot more overlap between IDEA and the other statute that you might imagine. I think they make an interesting practical point. Often when someone is bringing a case initially, they don't have much a clue what they're suing under or what the exhaustion requirement is going to be. So the fact that they've initiated IDEA proceedings may not be very meaningful.
Shouldn't be held against them, at least according to the concurrers. So that's, of course, a very big deal. I think all of us who've litigated in this area know that massive numbers of cases that are trying to get damages relief, especially, are thrown out on grounds of exhaustion. And a number of cases that are seeking other things are thrown out on grounds of exhaustion. There's a very interesting footnote in the case saying that, well, both the government here and the parents say what you really ought to do is look at the relief sought, the remedy sought, in the sense of, well, do you want damages or do you want something else? If you don't get damages under IDEA, which the Supreme Court has said in dicta, and which the consensus of all the other courts is no, you don't, then a damages claim doesn't need to be exhausted. And the court reserved decision on that. So that's still up in the air. I think there is concern that there'd be an end run around the exhaustion rule if you could just attach a claim for damages to any other claim and somehow get it out of the administrative process. So I wouldn't be terribly optimistic that that would be the rule that winds up being developed. Nevertheless, this is perhaps an earth-shattering kind of development that really, I think, ought to be noted. And the other thing, we mentioned this a little bit before the session got started. For those folks who might have been involved or at least know of a rather prominent Seventh Circuit case called Charlie F. that enacted what I would describe as a draconian, some would say almost absurdly draconian, exhaustion rule for the Seventh Circuit, saying that basically anything that had to do with special education needed to be exhausted. Westlaw is now listing it as abrogated. So that's kind of a big deal. Looking actually at the exhaustion cases since then, though, the results are kind of mixed. There have been some cases that have said, no, of course you don't need to exhaust, cite Fry, and a few others that say, well, Fry doesn't change the basic regime that you have to exhaust if it's any case having to do with a free appropriate public education. So it's a little hard to see exactly how this is going to play out in practice. So let me just pause for a second there, because I know that there might be folks with special interest in this. If not, then maybe let me move on to the next big deal case. The next big deal case is this Andrew F. one, which again is a bit of a landmark for the Supreme Court. The Supreme Court has only had one case dealing with the guts of the free appropriate public education obligation, or what I would describe as what is appropriate education. And that's the Rowley case back in 1982, involved a kid who was deaf, wanted to have a sign language interpreter, but seemed to be doing okay, at least in the first grade in her school. Supreme Court, in a somewhat contradictory opinion, basically says the kid and parents lose. At one point saying, we're just looking to this particular case and saying that with a child like this who's doing actually better than average in a general education public classroom, all that they really can expect for appropriate education is that, enough education to do them well, and with the hearing aids and other assistance that the child was getting, that's good enough. On the other hand, the court also made a number of comments about saying that, well, what we were looking for, what Congress was looking for in the statute, was providing meaningful access to education, a basic floor of opportunity, something that made it look almost like a minimal duty, although they didn't actually use language that was that extreme. And at one point talking about how the benefit has to be meaningful, but not in any clear way that established that as a standard. They did, on the other hand, reject a standard that the parents had advocated for and that actually the lower courts had adopted, saying that you had to maximize the benefit to the kid with the disability proportional to the maximization of educational opportunity for kids without disabilities that the school district offered. So they rejected that. They had all this language about a kind of floor or access type level, and they rejected the parents' claim, and that's pretty much where things have stood for more than 30 years since then. In this case, you've got a kid with autism mostly manifested with a lot of behavioral problems that include things like screaming in class and climbing over things and people and a lot of outbursts and problems of that type. The public schools develop programs for the child, but the parents don't think that the child's making much educational progress. And in fact, they particularly are concerned that the IEPs that Andrew has don't vary much from year to year. And the thing that really sets them off and starts the pattern of litigation is that the 5th grade IEP looks pretty much to them the same as the 4th grade IEP. They take the kid out of the public school, enroll the child in a specialized autism academy. Lo and behold, the child does dramatically better in terms of educational achievement once the autism academy develops a quite elaborate behavior plan for the child. They then, of course, pursue the IDEA administrative process and ultimately go to court to try to get tuition reimbursement for all of those private services. In this case, I believe it's the 8th Circuit, says the problem with that is that we think under Rowley, all that you get is more than de minimis or merely more than de minimis educational benefit opportunity. And the child here was making some educational progress, albeit not as much as the parent wanted or expected, or apparently as much as the child was capable of with appropriate behavioral and educational services. That goes up to the US Supreme Court. This one is a unanimous opinion by Justice Roberts, although the parents had more or less invited the court either to overrule or to limit Rowley. The court does not do that. But it says that the lower court's interpretation, actually I think it was the 10th Circuit, I think I gave it the 8th, interpretation was wrong in saying merely more than de minimis, that instead kids are entitled to appropriately ambitious goals, the opportunity to meet challenging objectives under the law. And Rowley doesn't really say anything different from that. All that Rowley was saying was that for a child who's in general education, that will normally be measured by the same things that it's measured for kids without disabilities, whether the kid is passing from grade to grade, just as the kid in Rowley was doing. So there's no overruling of Rowley, but whatever might be thought of as these more negative emanations from it or interpretations of it do wind up being thrown out. The court might be viewed, and some observers have felt this quite strongly, as creating a bit of a divide between kids in general ed and kids not in general ed, perhaps not fully realizing, of course, that there are a lot of kids sort of in the middle there. But for kids in general ed who are kind of like the Amy Rowley child who's deaf but otherwise doing fine in school, the court says you'll measure this by the success in passing from grade to grade, with a footnote saying, but we're not saying in every case that'll be enough. We're just saying that in general that will be true. But for a kid who's not in that situation, you have to have something more, markedly more, they say, than merely de minimis, and they return the case to the lower courts to figure out exactly what that will mean in application here. So this again is quite a big deal. I probably should say, and maybe as a word of caveat here, the court does not give a ringing endorsement to a few of the lower courts that had said it's meaningful educational benefit, and that's the standard that Rowley came up with. The court just doesn't talk about that. So I don't know if you can really call it that kind of an endorsement. They also say that the parents are incorrect in looking for something that looks like proportional maximization, which is what the parents wanted in Rowley. We're rejecting that as well. Finally, the court says, and we're not doing anything to change what Rowley said about the importance of deference to school authorities and their own decision-making processes. So it's not as though, maybe it isn't quite earth-shattering, but at least it's a little earth-tremoring or something. It really does perhaps change matters. In looking at the lower court cases since then, it's really a mixed bag. You have a few of them sending cases back saying, hearing officer, you applied a Rowley standard that looked very minimal. We think you should take another look at it under Andrew. Other courts saying, they applied Rowley. They didn't say merely more than de minimis. Looks okay to us. Looks okay under Andrew. So it's really hard to say exactly what the upshot here is going to be. Let me pause for a minute or two on that one as well. Have you all been seeing any of this yet? This, of course, is a little more recent than Fry, but it comes up probably more often than the exhaustion issues.
Let me just interrupt for a second. Those of you on the phone, excuse me, those of you on the phone, we're getting some feedback. If everybody could put their phone on mute, please. Thank you.
No feedback from the room. Okay, well, let's move on right ahead, you know. So that's sort of the big developments and the ones that everybody, I think, will think of as the big hairy deal cases of the term. Just to kind of go through, I tend to think of a lot of the special ed stuff more or less the same way that you'd follow through with a case, or at least with a kid going through the special education process. So I begin with things like evaluation, eligibility, move on to things like appropriate education and the IEP, move on from there into issues about IEP implementation and the like, and only then get into the issues that have to do with the dispute resolution process, and follow that pretty much all the way through it. So that's the very broad outline. To begin with, though, I think you really have to focus on child find, eligibility, evaluation, and the like. And there are some developments that are local here and some that are more national. The only one that I thought was really remarkable at the local level is the Jason O case that came out of the Northern District. I've got Jason O / or hyphen Ostby here. The lower court came out with a quite elaborate opinion. The case went up on appeal. The issues that were still present as of appeal were the kid's prospective placement and a claim for attorney's fees. It turns out that by the time the case got to the appellate court, the district no longer wanted to change the kid's placement to the one that the parents objected to. And so the Seventh Circuit ultimately vacates on the ground that the case is moot. Nevertheless, it's really vacated on other grounds, so there may be some precedential effect of the opinion in the lower court. And certainly if you're trying to predict what Judge Blakey will do, it's more than a little bit of predictive effect. So we should probably pay attention to the case. the part of the opinion that I'm stressing here, and there are other parts that I'll mention later on, there was a claim on the part of the parents that this child had been doing badly in terms of behavioral adaptation to the school setting, pretty much from preschool all the way through kindergarten, which he actually wound up repeating, and into first grade. The school district was willing to assess him and designate him for special ed, but only in the area of speech and language. The parents kept saying, no, there's something more wrong here. Shouldn't you be doing more in the way of assessing? The court, for its part, decides against the parents on a claim that they ultimately make, saying that the child should have been assessed earlier. And certainly immediately after the parent made a quite explicit request for the assessment, saying that although the school district was on notice perhaps of a need to assess, they actually were doing quite a bit of behavioral intervention, and the court didn't seem to think that the failure to do the assessment right away was something that the parents could complain about, given that the school district did have some knowledge of what the behavioral problems were and was responding to that during the period of time before the institution of a formal assessment. So in some ways it looks almost like a harmless error kind of a case. It isn't precisely that, but it is yet again a kind of thing that probably emphasizes that if you're acting as an advocate, you want to make sure that a request for assessment gets in early and is quite explicit, rather than being something that the district might have some ground not to take as seriously as perhaps it might. So that's that, and we'll mention a little more of the case later on. The other cases are non-Illinois cases. The LJ case, if there's an earth-shattering case, at least in my humble opinion, that's not one of these two Supreme Court ones, this one I think is it. I would view it as the single most important case of the last year or so, apart from what the Supreme Court came up with. And the reason for that is LJ involves a kid who has a bunch of what you might describe as psychological or emotional type disabilities. Everybody seems to agree that that qualifies the kid under the eligibility standard, which, as folks who do this know, basically requires one of these 11 designated disabilities that's in the statute, and by reason thereof is in need of special education. Everybody agreed, and that qualified the statement I just made, that the eligibility criterion of having the stuff you needed for emotional disturbance was in fact met. But they disagreed on whether the child was in need of special education, and the Pittsburgh School District, which is actually a suburb of San Francisco, kept saying, well, no, we've done a bunch of things to adapt the child's curriculum, to adapt the child's program, and the child is performing satisfactorily academically with those various adaptations, so therefore the child is not in need of special education. What the Ninth Circuit here said, though, was that if you look at the various accommodations that the kid is getting, they are effectively special education. In particular, the kid was getting specifically designed mental health services, assistance from a one-on-one aide, various clinical interventions from behavior specialists. Those would not be services offered ordinarily in general ed. So if the kid is succeeding by virtue of these interventions, if anything, that proves that the kid is in need of special education, rather than undermining the conclusion that the kid's in need of special education. So I think that's a big deal. certainly you see very often school districts saying, no, the child's succeeding academically because of these accommodations we've made, so therefore the child is not eligible, therefore the child's not covered. You know, in some ways, of course, it's always been a little paradoxical why it is that school districts resist special ed eligibility, because you can't spend special ed money on the kid unless the kid actually is eligible. On the other hand, it does seem that some school districts are just concerned about statistics, you know, numbers of kids in special ed, which doesn't really seem to me to make much sense. It's probably true that there are some concerns about labeling, you know, that the kid's going to be followed by the label, although I've always felt that the bigger concern is the kids being separated from the mainstream rather than the kid having an IEP or some form of designation. Kids are going to latch on to whatever it is they want to latch on to if they're trying to shun or prove that they're better or something else. And you can always try to create interventions to deal with that kind of a problem. Probably there are some school districts that are concerned that if they designate the kid as special ed eligible, that then they're a lot less free to impose disciplinary measures. And that can be a reason, I suspect, that they resist eligibility. And it's true that, you know, there isn't the same level of accountability with an IEP and with the various procedures that you've got under IDEA that you have if you've simply given accommodations on an informal basis. So it's important, I think, that this is an instance where a court says, nah, wait a minute, you've done all these things to try to avoid the designation, but you can't escape. In fact, what you're doing is determining that the kid is eligible rather than the other way around. So I think that that's kind of a big deal. What other cases have we got? Well, the couple of other ones are ones that are, just to my mind, really interesting fact patterns. So the Cape Elizabeth case, this Doe against Cape Elizabeth, is a First Circuit case. Kid generally is doing okay, but he has a big deficit in the area of reading fluency. School district resists finding the kid eligible. The court says here, well, you know, the key thing about this is that the statute, at least as amended in the late 90s, requires assessment in all areas of suspected disability and goals in all areas of identified need. And if you've got a deficit like in an area, say, of reading fluency, that in and of itself can be enough to mean that the child has a specific learning disability that makes the child in need of the interventions that would be special education. And that's irrespective of the fact that, you know, on the whole, the kid's reading isn't all that bad. And so I think that's a big deal because it, once again, emphasizes this idea of you've got to look to each of the specific areas. You've got to look to every area in which you suspect disability, and kind of a general or overall doing okay type thing doesn't make the kid ineligible for special education. The Timothy O case is another real interesting one. This is a kid who has a bunch of difficulties early on in school. Various of the school personnel keep saying, kid kind of displays some indications of autism. Maybe we ought to be looking into that. But in the course of testing for other things, when they're doing a kind of a general eval of the kid, the school psychologist decides to sit in for a little bit and says, kid doesn't look autistic to me, and vetoes the idea of doing an autism assessment. And so it isn't until many months down the line that the kid ultimately gets assessed for autism and found designated as autistic and gets services specifically to address autism. And the court says, no, that's no good. You had reason to suspect that the kid had a disability in this specific area. You have to assess in all areas of suspected disability. And you didn't do that. And so the parents wind up being entitled to a remedy for that. And that's the Timothy O case. So that's it with regard to these things. Obviously, there's more that went on, but those are the things that I think are of big significance. Let's talk just for a minute specifically about response to intervention. This too is kind of a big thing in recent ages. The particularly after the 2004 revisions to IDEA, school districts have jumped on an approach to evaluating, or at least to dealing with, what might be learning disabilities, of giving targeted interventions over time that proceed in tiers or in steps of greater intervention to try to get kids who are low or behind the curve, especially with regard to reading, up to a level before really doing anything that you'd call a special ed intervention. Even though, of course, some of what they're doing sure looks in some ways like special education. And the idea is that since a lot of the other ways of determining whether a kid has a specific learning disability yield very divergent results depending on the examiner, the area of the country, what time the testing is done, and often don't show up a positive indicator for specific learning disabilities until the kid's 9 or 10 or so, then this might be a better way of dealing with children and separating out those kids who simply aren't being given good enough instruction from those kids who might actually have a specific learning disability. The court in this case said that if the child is making progress under RTI, but there's a suspicion that the kid could be doing better under targeted interventions that would be deemed special education, you can't simply go ahead with the RTI and delay doing a more comprehensive evaluation of the kid. Now, the U.S. Department of Education has pretty much said the same thing on more than one occasion, but it's been a little difficult to find court cases that have said that quite so explicitly. And so this being one that actually does that, I thought the Greenwich case was worth looking into. The court also makes what I think is a kind of incontrovertible point, that you, under IDEA, can't rely on a single evaluative measure. It's true that in a way the school district wasn't saying only rely on RTI to determine if the kid has specific learning disabilities, but in a way it was saying that by delaying the evaluation until RTI had run its course. So what you were doing was you're not finding the kid eligible for special ed or even assessing the kid thoroughly for special ed on the basis of the single indicator. And that's no good. So that, once again, is worth noting. People know that under the statute, parents are entitled to an independent educational evaluation at public expense if they disagree with the school district's evaluation. And in fact, it's up to the school district, if they're notified of that, then to demand a due process hearing to show that their evaluation is appropriate. There have been quite a number of cases on this topic, and in particular, whether this independent educational evaluation at public expense has to be provided, or if the parents have gone out and gotten it, whether it has to be reimbursed. There's a local case where the district court, Judge Kendall, says, no, you don't get reimbursement for an independent educational evaluation, going at some length through the various evaluations that the school district does and saying that they looked adequate and that the parents didn't prevail on this issue of whether the school district's evaluation was good enough. Interestingly, the one thing that the parents really latched onto in this case is that the school district seems to have lost some of the materials from the psychological eval. Nevertheless, the court said that, well, still the services were based on the materials before they got lost, so the problem that might present doesn't change things. So that's one, I think, fairly important local case. It's actually under appeal at the moment, and I know the attorney feels that the court really just overlooked a lot of important factual issues, but we'll see what the Seventh Circuit does with us. There's another end to the Jason O case as well that deals with IEs. The parent actually prevailed on this issue below before the prospect of relief issue winds up going up to the Seventh Circuit, and ultimately the opinion is vacated. The big development that comes out of this case is I don't think I see anybody in the room who had me for torts. Nobody wants to identify themselves, but anyways, folks may remember the collateral source rule. You memorized it for the bar exam and then promptly forgot about it, didn't you? You know, it's this idea that despite the fact that something's covered by insurance, you still get damages. Doesn't really matter much anymore because everybody's insurance policy says you have to pay back the insurance company anyhow. Anyhow, the issue here was whether the parents were entitled to reimbursement for the evaluation for their net cost after insurance, or as if they hadn't had any insurance that paid for part of it. And the court says, they didn't actually cite the collateral source rule stuff, but says, now you get full pay. Insurance is your business, forget about it. So worth noting, you get full reimbursement rather than anything else. The couple of other things that are other developments worth paying attention to, there's this Sabat case, Sabat letter, I guess I should say, from the US DOE saying that the standards for an IEE, for the evaluator who's going to be doing that, need to be the same as those for the school district, and you can't hold the independent evaluator to a higher standard of qualifications than you, the district, would require out of your own evaluating personnel. Interestingly, the Seth B case says, yeah, you know, you follow the qualifications that the district has, but then says, yeah, but substantial compliance with educational agency criteria is good enough. And they send a case back to determine whether there's substantial rather than technical compliance. So it could be that your examiner might be able to be reimbursed even if the qualifications are in some technical way not what the district requires. Interestingly, the court also upholds a money cap, a $3,000 cap, but says that that's being upheld because the parent could have argued that it wasn't adequate under the circumstances, and they didn't. So that's it with IEEs. Let's move on for a minute to the IEP process and everything else. Andal, if you didn't catch it when it first came out, is worth devoting a brain cell or two to. It's a letter from the Department of Ed that says there is no requirement that the parent has to warn the school district that they're going to show up at the IEP meeting with a lawyer. And that the IEP team or the school district cannot condition the IEP meeting on the parent not having a lawyer. And sort of hints that to do that, or even to postpone the hearing under those circumstances, or postpone the team meeting, would be a form of retaliation. So that's, I think, a bit of a big deal. I don't know whether it's necessarily wise to fail to warn the school district that you're going to show up with a lawyer, but it certainly is within your rights to do so, says the US DOE. What are the other things that might be of interest here? The MC against Antelope Valley, you know, if I had to nominate a runner-up for non-US Supreme Court cases that may be of significance, this one probably would be it. It's a, people may have heard of a judge called Judge Kaczynski in the Ninth Circuit. He used to be a law professor. He is noted for writing somewhat offhand, but often very entertaining opinions, probably not to the litigants, you know, but to anybody else. Interestingly, in this case, he felt that the school district and the administrative law judge really did a bad job on quite a number of things. And we'll talk a little bit about some of the things that that Judge Kaczynski faults the ALJ for. But particularly with regard to the IEP process, the judge here says for the Ninth Circuit that it's crucial that the school district not amend the IEP unilaterally, and the parents can not only complain about that, but also will prevail on a claim that that violates the right to free appropriate public education and parental participation, even if, as in this case, they amended the IEP to give the kid more services. So you might kind of think, well, that if there's a harmless error anywhere, that would be it. But he makes the interesting point that, you know, if the parent doesn't really know what's going on, the parent can't really exercise procedural rights. And the fact that the school district is amending the IEP is an indication that something's wrong, and the parent really ought to be aware of that. The unilateral amendment per se is a procedural violation of IDEA. They also said that, the Ninth Circuit says that failure to specify which assistive technology is being offered in the IEP is, again, a harmful error with regard to the IEP process. So that, yet again, is, I think, of big significance. Yeah, please.
I'm curious about your hesitation against parents not warning about an attorney's presence. Do you think that kind of sets a tone that's litigious or chills discussion?
That's the concern, I think. Okay. You know, if you do have the lawyer there, it inevitably is going to raise tensions. But if you at least give some warning, it probably will have a chance to diffuse them. But you know, there's probably an exception to that rule. You know, I've mentioned, I think, more than once that it's not a bad idea if you can spare the personnel, which relatively few people can, not only to have an advocate or a lawyer at an IEP meeting, but just to have somebody to take notes. Because there have been times, at least in my experience, where what school personnel say at the IEP meeting winds up looking a little different from what they say at the due process hearing. So that's yet another issue. Now, it could well be that sometimes the parent's story changes too. So I don't want to make that one-sided, but I do think that there are benefits to having somebody who's able to take notes as well. Let's talk a little bit about some of these couple of other cases. We can probably kind of group these together. They're basically two Second Circuit cases, different factual contexts. What they essentially say is that you've got to tie up the IEP to what actually is in the assessments. The AM case says, perhaps even more drastically than that you have to follow the consensus of the IEP team. So you can't have the IEP team saying one thing and then the school district administrator saying, no, we're not going to offer the service. Which, if that's followed by courts generally, I think would be something of a development. The LO case is also a bit of a significant one in that there have been a couple of cases that have done this as well. What they say is that various procedural errors that the school district makes may not each individually amount to a denial of free appropriate public ed or denial of parental participation rights, but cumulatively, the various procedural violations did. And so that's, I think, again, a point worth noting, that you can have a school district that does a number of smaller things and that winds up infringing the parents or the kids' rights. On to appropriate ed. Well, I'm not going to say more about Andrew, unless there's things that you thought about in the meantime that you want to try to address. Let me just mention a little bit of what's developed with regard in other areas that might be a little bit different from the Andrew decision. So the Dear Colleague letter really, to my mind, merits attention. It's a letter on behavioral supports, and generally speaking says behavioral supports are a good thing, you know, right? But more specifically emphasizes this idea that behavior is an area in which intervention is required, you know, which is contrary to what you see in at least some of the case law, and certainly you see in some positions taken by litigants, that, well, the kid's really doing well academically. Sure, the behavior is utterly out of control, but the academic indicators are fine. Therefore, the kid's not entitled to more services. USDOE is saying, no, that's not true. What's more, they're saying that if the kid is, and this is sort of the tail end of the letter, constantly getting into disciplinary infractions, that's a strong indicator that the behavioral services are not right and that the child's not getting appropriate education. And that, too, I think, is something that needs emphasis. And then I just wanted to repeat the AM and the LO cases that we just talked about in connection with IEPs, because both of them do talk about the need for behavioral assessments and the need for behavioral services, in addition to talking about these problems with the IEPs in those instances.
Mark, I was just, you've cited a number of things from the Department of Education and guidances and things like that, and I just was checking the citations, and they're all, you know, 2016 and before that. Do you have any sense of whether, you know, there's any possibility some of those issues will be rolled back or different approaches by the new administration? Not to put you on the spot, but are you getting a sense that there would be any kind of difference in some of these issues?
You know, that's a really good question. I guess, you know, if we're talking about elephants in the room, we've got Andrew, we've got Fry, and frankly, we've got the administration, however elephantine you might want to characterize it as being. You know, one of the big priorities for Secretary DeVos, for sure, has been school choice. It seemed that with regard to the sort of shadow budget that has been unveiled, that special ed specifically isn't being cut back upon. What I think is probably the greater concern to my mind is that general ed is being cut back upon. And it's not all or nothing. You know, kids by and large have some general ed, some non-general ed. And so the options with respect to general ed, I fear, are going to be a lot less desirable if all of these budget cuts kind of come through. Now, of course, that doesn't describe really a good answer to Barry's question. The bigger problems that might be hidden in the budgetary problems for things like these interpretations could be, first, the fact that the government appears to have not exactly zeroed out, but at least greatly diminished the support for offices for civil rights in all of the federal agencies, including USDOE, and OCR is one of the entities that gives these determinations. And, you know, it really does depend on who gets appointed to the positions of the people who are going to be writing these letters or these various interpretations. So it's a really good point that you could see rollbacks on some of these issues. Interestingly, that didn't much happen during the Bush era. It didn't really even much happen during the Reagan era, for those of us who go back that far. But it's an area of real concern. On that maybe not terribly happy note, I don't know. Let's talk for a minute about also a not very happy subject, peer harassment and bullying. Big issues here tend to be whether you're entitled, again, to appropriate services to deal with peer harassment and bullying as a matter of IDEA law, and whether you can recover damages of some kind against the school district under Section 504 of the ADA, almost on an analogy to sex harassment, hostile environment, or race harassment, hostile environment cases. Answer for the second of those two questions is courts seem to have a consensus of yes, you may, but at the minimum, they seem generally to be saying, yeah, but only under Title IX type standards, which require either intentional conduct on the part of the school district itself or inaction by an administrator with actual notice and the ability to do something that amounts to deliberate indifference. Now, I've argued that in fact that's incorrect. If you go back to the cases, particularly to Alexander against Choate, it appears that damages remedies may in fact be available for conduct that would not be viewed as intentional to the extent that the Title IX and Title VI case law developed to require intent in cases of those type. But it's been a hard sell. I'll talk a little bit later on about one opinion that seems to go in the direction that I've been arguing. The Third Circuit has, at least at the district court level, some cases that seem to go in that direction. Nevertheless, this Doe against Columbia Brazoria case out of the Fifth Circuit requires this actual knowledge type approach both to a Title IX harassment claim and effectively to a Section 504 ADA claim on peer harassment. So the administrator has to have actual knowledge and then be deliberately indifferent, at least, for there to be a damages claim that would lie. Interestingly, TK is a case out of the Second Circuit. This one got a bit of publicity some years ago because Judge Weinstein, in a more than 100-page opinion, went on and on about the bad effects of bullying and the fact that bullying is something that would interfere with appropriate education. The Second Circuit doesn't issue a 100-page opinion or simply adopt Weinstein's opinion as its own, but it does say that at the minimum, the failure to even be willing to talk about the parents' concerns of bullying and harassment of the kid in school is denial of free appropriate public education and parental participation rights, as is the failure to provide appropriate services to deal with that or appropriate accommodations to deal in some fashion with that. So you might have an IDEA remedy for the bullying and harassment, as well as perhaps, if you can jump through enough hoops, a damages remedy under the ADA in Section 504.
Mark, is that Doe case, I mean, isn't that sort of inconsistent with generally how ADA harassment cases have been interpreted? Is it because it's in the school context, they're taking a harder line maybe, or?
That's an interesting point. You know, you can certainly argue, as I've done, that the provisions that would apply to harassment aren't just the failure to provide free appropriate public ed under Section 504, or not just failure to accommodate, although not that those things are not significant, but also that it looks more like the stuff that's in Title V of the ADA, the anti-retaliation provisions. There's actually an anti-harassment provision that's based on Fair Housing Act amendments rather than based on Title VII or even based on Title IX, Title VI. So I think, in fact, it is broader than that. But that analogy to Davis, for those folks who know the Title IX case law, is just so tempting
Yeah, right.
that it's what courts have latched onto. Um,
You mean the deliberate indifference?
Yeah, exactly. Actual knowledge plus deliberate indifference. Anybody who's really into that topic, so I've got an article, the tail end of which addresses this, that was in the Boston College Law Review a couple of years ago. I probably mention this to every audience that I talk to. If you want to get free access to law review articles, there's a website called ssrn.com, and you can search by author and download most any recent law review article for free. Do it soon because it just got acquired by Elsevier, and Elsevier, I'm probably not libeling and saying that they don't do anything for free. So they're still doing it for free now. So do it while you can. In any case, so I've got a fairly elaborate argument on why the standard, in fact, ought to be different from that. Anyhow, let's maybe move on to related service and assisted technology. You know, we talked a little bit about the requirement of putting assistive technology on the IEP. Couple of cases out of district on this one. The second one maybe isn't that big a deal, but I just thought it was quirky enough to be given a mention. The parents said, and they had good support for this, kid really needs an iPad. And it goes all the way up to the district court that says, yeah, the kid really needs an iPad. So if you're trying to get an iPad for the kid, this is the case to cite. The LMH case is probably a little more important. You know, people have probably heard the slogan now, what do we want, science? When do we want it? After peer review. Anyhow, there is language in the post-2004 IDEA and the regulations about relying on peer-reviewed research for services for kids, but there's almost no interpretation of that at the court level. There is now, where a court says that the determination of the speech services that the district made was not based on peer-reviewed research, whereas the parents came up with a bunch of peer-reviewed research to support the claim for different and more intense services. So that's worth noting if you're an advocate, I think, that there is support for this. Let's talk about least restrictive environment. Yet more of the Jason O case. School district wants the kid in a self-contained setting, parent doesn't. School district wins, parent loses. That may be about all you can squeeze out of Jason O. Again, to my interpretation on LRE, maybe it's a bit idiosyncratic, but I think it's in my humble view, the correct one, that the key thing really isn't how restrictive the environment is. The key thing is what services the kid gets. You can make a real unrestricted environment work by adding a lot of services. If you don't do that, of course the kid's going to need a more restrictive setting. And I felt, again, in my humble view, that maybe the judge didn't pay quite enough attention to that issue. Nevertheless, it is true that in this instance, the court felt that the more intense, more restrictive environment was justified, that there were at least some opportunities for being with kids who were not disabled. On the other hand, there's a, and this is one of only a couple of due process hearing cases that I put in. You know, obviously these aren't necessarily precedential, but they're pretty predictive, at least of what a given hearing officer might do. And sometimes they're very well reasoned. In this one, the hearing officer says, yeah, the school district wants to take the kid out of the school district and put the kid in a therapeutic day school, but the parents have made a quite convincing case that with appropriate services that the district hasn't really tried, that the kid can succeed in a mainstream setting, therefore parents win. And it's a very exhaustive discussion of that argument. So I think it does merit attention. You can get this up through the ISB website, although it, as with most other things on the ISB website, it does take a little bit of digging to actually get there. A couple of non-Illinois cases that deal with LRE. LH is almost a classic Down syndrome case where the kid can in a way be accommodated in the general education setting, but it's quite clear that the child will not be doing so, at least as moving into junior high, at the same level of achievement, if you will, or knowing the same things that the other kids in general ed will. Court says that's not an obstacle. The fact that the child won't be able to achieve at grade level doesn't mean take the kid out. It instead means you have to adapt the curriculum. The Brown case is one that almost is a procedural case, saying that it's important that the LRE be discussed at the IEP meeting and that the IEP itself contains some discussion of the LRE, which is usually on the forms, but that sometimes winds up being ignored. Let's move on to a couple of other issues, not exactly related, but maybe somehow sort of related. Smith v. Meeks, another Northern District of Illinois case. This involved divorced parents. The mom, who's non-custodial, wants to invoke due process. Father, who's custodial, does not. You don't get due process. Interpreting Illinois law, and with that IDEA, the court says the non-custodial parent has the right to notice, has the right to access to records, but doesn't have procedural rights in the sense of being able to invoke due process. That's pretty much the consensus as far as I can tell among other courts. And I did want to mention a word or two about, I guess we should move on, about records, access, and privacy. There were a couple of cases in the last year from Judge Shader, who I always remind every audience that I talk to, actually went to high school with my mother, which indicates that he's been around for a while.
Where was?
In
Chicago?
Milwaukee,
Oh,
actually
Milwaukee.
Washington High in Milwaukee. My mom's no longer around, but Judge Shader sure is, and deciding cases and saying that, interestingly, this actually is more of a preclusion issue on records, that you can't get a preclusion from a decision having to do with records under Illinois law until the time for appeal has lapsed. But you didn't know that. You probably did memorize it for the bar exam. Repeating what the Stanek case had reminded us of last year, that, or 2 years ago, that Section 1983 is available for IDEA violations in the Seventh Circuit, but the Seventh Circuit won't tell us exactly when or why or how. Why, I think, is right, because it's a statute that confers enforceable rights and is obviously not intended to occupy the field. So under Hornbook law, it shouldn't be unavailable as a basis for 1983 liability, but courts, most of them, except for the Second Circuit, the Seventh Circuit, and a couple of others, have said, no, it isn't available. So we're reinforcing that once again. Let's move on to sort of the stuff of what happens when things go kablooey here and you actually wind up in dispute. I did want to say a word about settlement-related type things, because I always feel that that settlement is kind of an underdeveloped issue. The Campbell-Gomez case is nothing to do with special ed. It's a consumer class action case. The target of the litigation offers to the named plaintiff everything and more that the plaintiff would be able to get in the litigation, and then says, the case is moot because I've offered it. Goes all the way up to the Supreme Court, and Justice Ginsburg, in her civil procedure teacher mode, says, no, it's not. An unaccepted offer is a legal nullity. There are, however, other cases from lower courts in special ed contexts saying, the school district's offered the parents everything they want, the case is moot. Applied to those contexts, this case would say, no, it's not. It's only if the offer actually is accepted that it winds up being moot. So that's a big deal. Couple of other cases that may be of significance, Nardella cases here. Really, actually, let's move on to the next slide. The Nardella cases basically just stand, to my mind, for the proposition that in a due process proceeding, that you can't take up on appeal hearing with respect to entities or people who are not parties in the due process hearing itself. Does that mean that maybe then you have to go to the hearing officer, get the hearing officer to dismiss out people who you know the hearing officer is going to dismiss out, and then go ahead and sue them afterwards, saying that, well, we tried? Answer, maybe yes. And so that probably is worth putting some effort into. So that's sort of on one hand the settlement issue, and on the other hand some stuff with regard to due process complaints. There's other things going on in that topic, but I think that that's probably the most important. What's the most important thing going on with regard to limitations for due process? It's got to be a non-Illinois case, the GL case. This is the only, I think, 2015 case that I threw in here. And the reason is that it's been adopted by a couple of other courts since then. What it does is says, as long as your due process complaint is brought within the statute of limitations, the default one being 2 years, of when you knew or should have known of the violation of IDEA, that the remedy for that violation can go back forever to the beginning of time. There's no limit, actually, as long as you brought the due process action within 2 years of the known or should have known date. They say it operates just like a plain old statute of limitations. If back when you were 2 years old, the surgeon left a sponge in your body and you didn't realize it or have reason to realize it until you were 35, you can go back and within 2 years in the state of Illinois, sue the surgeon for medical malpractice, at least in the absence of a statute of repose. And that's the same rule that the Third Circuit adopted with regard to due process. Now, it's much more elaborate how it is they get there, but that's the upshot. And the Ninth Circuit has adopted that in the Avila case, and a district court in DC has adopted it as well. So it's kind of important, I think, in that regard. Does actually, interestingly, create all sorts of issues with regard to comp ed. I mean, do you get comp ed then going back to the kid's kindergarten age, even though the kid is now a senior in high school? Well, if you didn't know or shouldn't have known, maybe the answer is yes. Just a word or two about conduct of the due process hearing to throw in a few more things about this. Jason O, once again, I indicated it decided against the parents, among other things. It decided against the parents on cumulative evidence was excluded, said the hearing officer was okay doing that. Excluding a witness who actually was an advocate as well from sitting in on the hearing when the advocate wasn't testifying, that's okay. And restricting rebuttal testimony on the child's educational performance in a later school year, the court also said was at most harmless error. Now, one thing that folks probably do want to make a note of, there's been a lot of issues saying that since you're really looking at the IEP prospectively, whether it offers the opportunity for appropriate ed, there have been some courts and hearing officers that say, so therefore the fact that the kid made a great leap forward when put in the private school in a way isn't really relevant. It's merely the fact that the kid was offered or not offered appropriate ed at the time. Interestingly, in Andrew, the court, although it doesn't have occasion to really say what it is it's doing with this, does talk at least a sentence worth of length about the fact that the kid did make dramatic progress once the kid was in the private school, which obviously does, at least to the court, seem to be relevant evidence. And so this is maybe, in a way, pushing back a little bit against what Jason O seems to have been endorsing as an interpretation. Raglan, I threw in because it's local mostly, but the big issue on this one is that there were issues that had been stricken because of failure to comply with discovery at the hearing officer level, that the decision on that was not appealed, and the court said you can't then bring that up later on if you're not also appealing the decision about the sanction. And then finally, the BG case I thought I would bring in because the court approves the imposition of time limits on testimony at hearing, at least if the hearing officer is willing to be flexible about it and doesn't seem obviously to be committing a procedural error. I'm going to be moving a little more rapidly because we're running a little low on time, but again, nobody's had the pleasure of having me in torts, but whoever's had me in law school knows I can talk really fast. So we'll maybe talk a little bit more quickly about some of these things. Jacksonville, I thought I would throw in. There's a big issue often, not so much about the fact that the kid under 1415J is entitled to remain in the kid's placement during the pendency of proceedings going on up from hearing officer through, I don't know, the U.S. Supreme Court, but trying to determine what the kid's current educational placement is. The U.S. DOE's interpretation and the bulk of court's interpretation is that if the hearing officer decides in favor of the kid, that creates a new status quo that has to be maintained, even if ultimately overturned by a district court, if the case is then continuing to pend and go up to a higher level. Jacksonville essentially says the same thing. A new status quo is created by the hearing officer decision. On the other hand, there's been a big issue, and I decided, no, I didn't, I'm jumping ahead. I decided to throw in two more or less contradictory cases on this. What do you do if the IEP is temporary, or if, as in the NE case, it's got multiple stages? Does that mean that the status quo then ends itself once the IEP runs out in time, or once stage one is over and stage two begins? The NE case says if it's this multi-stage, then the new status quo is the second stage. Dervishi, on the other hand, although it's not a precedential Second Circuit opinion, says, well, it's a temporary IEP, but it's the one that was there when the kid invoked due process, so it is the new status quo, and any IEP is effectively time limited, so 1415J can't be read to say if it's a time limited IEP, it doesn't create a long-term status quo, and that would create a terrible incentive because school districts would just create, exploding IEPs. So the court requires that this temporary IEP be maintained. Thought I would throw in just a little bit about class actions for those of you who might be so inclined. And I'll just mention a word about each of the three cases. So Smith is a case that looks a lot like the litigation that took place in Chicago Corey H on LRE. Interestingly, in this one, the Ninth Circuit requires that the lower court bring in a class of dissident people who don't want the remedy with respect to LRE that the school district and the class of parents who are represented in the case want to adopt. So it's kind of contrary to what actually happened in Corey H, although the dissident parents were a lot prompter in this one. The TR case is an interesting class action, not only on limited English proficiency services for kids in special ed, but also for their parents at IEP meetings and IEP related documents. And then I thought I'd throw in DL. This is almost identical to the Jamie S case that got tossed out in the Seventh Circuit, but that the DC Circuit in its parallel case in the DC area said with some modifications would be okay. The court ultimately holds massive hearings and decides largely in favor of the kids, enters relief both on IDEA and Section 504. The case has been on appeal now for almost a year, was just argued, so who knows what will happen with it, but I kind of recommend taking a look at it if you've got any interest in that topic. Wanted to mention a word about mootness. So you got Campbell Ewald out there. But you also do have this OSPI case. So if it appears that the school district no longer wants to move the kid, Judge Rovner and the Seventh Circuit is going to say your case is moot. And if you had a pending attorney's fees claim, that might mean that your attorney's fees claim isn't going to be alive either, although the court doesn't say much more beyond saying that the pendency of the claim itself doesn't negative mootness. So that's really what I wanted to do with that. Administrative exhaustion, we have Fry once again. I almost mispronounced this, the Mixis case is actually one about enforcement of a settlement agreement. And in a rather scholarly opinion, Judge Durkin tries to find federal jurisdiction for enforcement of a settlement agreement at the behest of parents against the school district, and finally comes up saying that yes, there is, kind of as a form of what might be called pendant jurisdiction that ultimately is being applied, supplemental jurisdiction. But in the way of doing that also says that in a claim like this one where you're trying to enforce a settlement agreement, exhaustion is not required. So that's, again, kind of a big deal as well. The Keener case, on the other hand, requires exhaustion for what is effectively a peer harassment or bullying case, even though the claim is brought under Section 504 in the ADA. This might be worth reviewing in light of Fry. Fry might very well undermine this, but it should be noted that it's still out there. It relies quite heavily on Charlie F. On the other hand, the BG against Claypool case is a case that says that exhaustion, this is in line with Seventh Circuit case law generally, is always an affirmative defense and actually has to be affirmatively raised by the defendant. That's contrary to what the Second Circuit and a few other circuits say, that says that completing exhaustion is jurisdictional and the court can raise it as an objection. But that's not the law in the Seventh Circuit. Gosh, with regard to other cases where the exhaustion has been required that are not in Illinois, there's a case dealing with isolation and restraint. This one is actually post Fry, where the court requires exhaustion. Reyes deals sort of more with abuse by staff rather than abuse by peers, but the court also requires exhaustion and applies Fry. So I wanted to kind of emphasize the idea that Fry may not be the indication that everything's going to be okay for exhausting or not exhausting administrative remedies. I'll mention a word or two perhaps about, so we mentioned statute of limitations for due process hearings. What about statute of limitations for court actions? Well, you know, there's the 120-day thing in Illinois for an appeal. What if your case isn't really an appeal of an administrative decision? What's the statute of limitations then? Well, according to Judge Dara, the late Judge Dara, it's 2 years, irrespective of the 120-day statute that applies to administrative appeals. And that's what the Stanek case here is. People, if you're not familiar with Stanek and you do work in this area, you should definitely take a look at the Seventh Circuit case from 2015 in the Seventh Circuit opinion in the same case, because it deals with a bunch of other issues and is really worth noting. The Vandalia case, so if you're applying the 120 days business, the school district here said, so therefore that begins to run once the hearing officer has decided a motion for clarification. Parent here and judge say, no, it's a 120-day statute that is told during the period of clarification. So the days that are before the clarification motion is made count. And the school district didn't do that, so the school district's appeal was not timely. So keep that in mind. It's more likely probably to trip up a parent who might have difficulty getting a lawyer than it is a school district. So certainly be aware of that. Maybe just mention a word about CP. Oh no, wait, I'm skipping too far ahead. CP is one that doesn't give a parent an injunction against enforcement of a hearing officer decision while the decision is pending, including the reimbursement parts, even though the school district says, there's no way we're going to get this money back out of the parent. And in fact, there's case law saying you don't get the money back out of the parent. The court is not sympathetic, to put it mildly. Compensatory ed. So here's yet again another hearing officer decision. The reason that I really thought this had to be in is that it's the classic case of the kid who does okay in high school, graduates from high school, and falls off a cliff. Basically seems to have no motivation, no interests, no nothing. The parents come back and say the kid should have been given transition services back ages ago. In fact, they didn't evaluate the kid from 2008 to shortly before 2013. And that is a reason the kid never got appropriate transition services. And the hearing officer says, and you get appropriate transition services as compensatory ed. So it's worth looking at. Can we still maybe take another 5 minutes, do you think? Or okay.
Kathy, okay with the 5?
Is that okay with
Thanks,
folks? The couple of other cases on comp ed that I think folks should know, and I'll mention them just briefly. MS says don't remand to the IEP team what the amount of comp ed should be, or in this case, more specifically, where the comp ed ought to be delivered, what setting it should be delivered in, because that's not the IEP team's job. It's a remedy. It's the hearing officer or the court's job, and the IEP team shouldn't be put in that position. What's more, says BD, and the fact that the kid is now getting appropriate services doesn't mean the kid doesn't get comp ed. So comp ed is something more. It's actually compensatory. It's beyond appropriate, which reinforces a lot of what the DC Circuit had said, but is worth, I think, once again emphasizing. Let's mention a word about tuition reimbursement as well. Another hearing officer decision, this one from hearing officer Leisner. Big thing on this one, you know, it might look in some ways like a standard reimbursement case where the school district doesn't provide appropriate services. But what jumped off the page to me on this is that the parent got a unilateral placement for the kid in a non-special ed school, a school that purported not to offer special education services. It did provide various adaptations to the kid, but it said, no, we don't provide special ed. The hearing officer nevertheless requires reimbursement. There are cases, notably out of the Second Circuit primarily, saying no special ed, no reimbursement. And I think this opinion is in some ways much more sensitive to that. It says, no, what really matters is whether the kid got something that benefited the kid. And after all, the parent is often in a terrible position to try to get appropriate services for the kid on their own. So it emphasizes that point. On the other hand, this LH case, I thought I would throw in one that goes in the other direction, out of Tennessee says, nah, the kid got placed in a Montessori school. It doesn't seem that, although the kid did make a lot of progress there, that the Montessori program was adapted to the kid's needs, no reimbursement, even though the kid was denied appropriate ed. What about 504? Well, 504, the cases that are local are mostly against private schools, and the parents lose. And that's that chunk of the Nardella case, the Thurman case, and the Martin against East St. Louis case. The Martin case, I guess, is a little bit of the exception there. The court said here that the problem is that the school district wasn't on notice of the fact that the child was being harassed on the basis of disability. So in some ways, it looks like a lot of some of those other harassment cases, but the other ones dealt with private placements. Non-Illinois, there's a lot going on here. There's an eligibility case, the BC case, that says just because the kid's eligible under IDEA doesn't mean the kid's eligible under Section 504 or the ADA. That's directly contrary to a U.S. Department of Ed interpretation, and I think contrary to the ADAAA. The Second Circuit manages not to cite either of those things. There's a case involving teacher abuse, which is the Goal case, that the court, among other things, says, well, it isn't clear that you've shown that kids who don't have disabilities aren't also abused, which can't be right. I mean, LC against Olmsted, the case on least restrictive setting for adults with disabilities says you don't need a comparator. On Colley, the Title VII case on sex harassment says you don't need a comparator. So that's got to be wrong. Paradise Valley is the one case that seems to adopt an interpretation that almost sort of, if you squint, looks like mine. It allows a somewhat broader range of damages remedy than other courts seem to be doing in harassment, or in this instance, improper restraint type cases. The Bow case maybe also does. That's a somewhat closer to home Western District of Wisconsin case, peer harassment case. Also doesn't require exhaustion for a peer harassment claim. So that one is worth noting. And then I just thought I would throw in a couple of other cases. These aren't really cases of the usual sort. They're OCR letters of finding. School's website has to be made accessible in the Santa Fe case. And in the Ladue case, they require captioning services for a kid. So that's kind of maybe earth moving, if not earth shattering. Then finally, I just thought I would throw in an attorney's fees bit. So Raglan is on limitations for fees claims and kind of reinforces what we've known about that already out of the McCartney case in the Seventh Circuit. MS, this says, it's worth noting, you don't reduce the attorney's fees for the fact that the parent failed on some issues if the issues are all arising out of the same facts. So that's kind of significant. And I threw in the MW case. It's a 504 case, says that although you don't get expert witness fees under IDEA, you do get them under 504. So if you can bring a 504 claim, even if just for the expert witness fees, it may be worth pursuing. And that's nothing, right? Nothing happened in the last year. So I don't know if we have time for questions.
Yeah. Any quick questions people might have?
MC. We're all stunned.
Okay, well, please join me in thanking Mark.
Thank you all.
So much great information. We really appreciate it. A couple quick announcements. If you're seeking CLE credit, make sure you signed in here. Or if you're on the phone or on the webcam, you need to either email me or click on the link that was in the email to get CLE credit. If you could all please fill out the evaluation. This allows us to continue to be CLE providers. And without it, we can't do that. So just take a few minutes and complete those for us. And then programming notes next month. We'll be meeting on the 4th Wednesday, which is the 28th of June. And we're going to be focusing on the issue of hate crimes and the intersection of disability, which is obviously a very hot issue right now. And then in July, on July 26th, we'll have Karen Tamley, who's the Commissioner for the Mayor's Office for People with Disabilities, to give us an update on the work that her office is doing. So I hope you can join us for both of those sessions as well. Thanks very much.
Thanks.
So did anybody stay on after the volume?
Yeah.
Oh, good.
Very relaxing.
Oh, good.
No, but he feels like I've been lost.
Oh, it did.
Yeah.
So, yeah, good news is that we had a lot of streaming events.
Yeah, what do you think happened?